the blues run deep. Crooked justice, a secret they keep. But I see through her lies, I see the truth. Gonna make her pay for what she do. Fanny's got a reputation to uphold, but her tactics are shady. Story untold, she thinks she's clever, but I'm on to her game. I'll expose her ways and put her to shame.
Hello, folks, and welcome to yet another trial day. Yay, 2 days in a row. Yesterday, we finally got caught up, somewhat. Yesterday, the judge decided no. Instead of 11 a.m., he decided no, 1 p.m. So we are going to start with what happened yesterday afternoon, and again, an absolute horrible decision from Judge Glanville. And I shouldn't be surprised at this point in time. I mean, we are 5.5 months in, but this one is a bit of a new level. So yeah, so that is what's going to happen for a couple, well, maybe an hour and a half, before we get to today's trial. All right, so at the stage, there and there. All right, so let's listen to Judge Glanville and the rest of the gang from yesterday to start with. Oh, Dave, there's a final 20 minutes of yesterday you want to hear, because Jesus Christ. But let's start with the first. Hello, Ghostery. Hello, Dave, Patrice, DK Cripple, and all the rest of you.
I'm in possession of, let's see.
Hi, Divans.
Which I'll mark as the next court's exhibit in order, and the attachments there too. Mr. Steele's email from May the 10th of 2024 at 4:50 p.m. In regards to motion in limine number 51. I'm also in possession of Mr. Steele's request on 5/14 of 24 at 9:08 a.m. Requesting to argue motion limine number 51 prior to the playing of another jail call, as he believes is inadmissible under law. And I'm also in possession of an IG post, Mr. Williams' IG Instagram records, which was sent to everyone. There are 3 Instagram business records. First one being pages 5651 and 5652. The next one being pages 5793 and 5794. And Instagram business record page 6828 and 6829, which the state is seeking to admit, I believe through the testimony of our current witness, Detective Racy. The court's had an opportunity to kind of study the issue because it's come up several times. And Mr. Steele, the court is aware that you've raised this issue at least 3 times, a couple of your colleagues as well. And that's okay, and the court has no issue with that. But I just kind of want to make it clear for purposes of there seems to be some issues about whether or not assuming that a foundation can be laid, and we've had some arguments and discussions about authenticity and admissibility and foundation, which is in one camp, and I think we've covered that already, and where these particular source documents have been pulled from in terms of Instagram and other jail calls, and the court's still going to adhere to foundation and make those determinations. But as a whole, the court understands that. Then there's another set of arguments that have been advanced, those being whether or not the statements themselves from these Instagram postings or other sources can be admitted. We've had several arguments and discussions about the admissibility of said statements. Most of them come in under statements of a party opponent. Then there's been the ancillary discussion related to that is, well, the requests for limiting instructions and the like, because these statements are only admissible as to one or the other.
Dave, why is the judge requiring foundation now? I don't think he's required much foundation throughout this case. Now, not exactly, because the defense has argued from then to Kingdom Come about the absolute lack of foundation and from the state. And now the judge seems to be fed up with it, and he will claim that it is regarding in furtherance of the conspiracy. And this is where he's going to say that the prosecution only needs to, in order for the evidence to be shown for the jury, it has to reach the preponderance of the evidence, as it's more likely than not. It's a scale and a feather. And that is apparently what the judge decides, not the finder of fact. So that is why he is allowing more or less everything in, because the prosecution alleges that everything going on between that person and that person over there, who has more or less nothing to do with the defendant, is still in furtherance of this conspiracy. And that is why he's allowing everything in for the prosecution.
This being a different type of case, since a conspiracy has been pled or has been sought in the state's indictment as part of count one, these statements also come in, and it's the court's opinion. We've had some discussions about this, about whether or not they come in for co-conspirator statements. To that end, I'm going to cover a couple of things that the court would like to put on record. To prove up a statement made by one co-conspirator in order to use it against another co-conspirator, there needs to be evidence of the following elements. 1, prior to the current trial, the defendant participated in the criminal agreement. 2, a confederate of the defendant made a declaration in furtherance of the conspiracy while the conspiracy was active and ongoing. 3, a witness who heard the conspiracy made the remark, testifies to it, and the content of the declaration is relevant to the case. And I'm quoting from Carlson on.
Remember, folks, this judge has allowed in jail calls where an unknown person is making statements. And he justifies it with this.
Central Foundations to Georgia, or Georgia Advocates, 3rd edition. The Georgia rule reference is found under OCGA 24-8-801D2, adheres to this federal counterpart and applies correspondingly. Accordingly, New Georgia and federal authority with emphasis on 11th Circuit Court of Appeals precedent should be utilized for the interpretation and application of this code provision. 801D2E provides that a statement is not hearsay if the statement is offered against the party and is a statement by a co-conspirator of the party for which was made during and in furtherance of the conspiracy.
Again, he is allowing in statements in jail calls from unknown people.
801D provides that admissions under the party opponents shall not be excluded under the hearsay rule. Under 801D to echo, The party admission rule includes statements offered against a party that was made by a co-conspirator of that party during the course and in furtherance of the conspiracy. And that cites Kemp versus the State, 303 Georgia, 385, 2018.
Hi, Dave. Oh, sorry.
Hello.
There. Hey.
Oh, hello. So these are unknown participants in a phone call, and these statements are being admitted?
Yes. The jail call is between a person who took a plea deal and somebody else. Now, they have a guess about who one of the other people are in this jail call, have no idea who the third person is in these jail calls.
Are they only the person who took a plea deal? Are they allowing only his statements in, or this unknown other caller?
All of it.
It's ridiculous.
Yeah.
Because you have the right. Not only is this a hearsay issue, you also have the confrontation clause in the Constitution, which requires that every defendant be afforded the opportunity to confront the witnesses against him. So if they're using the statements by this unknown person, then it's impossible for the defense to confront this witness.
Yeah, and that is what the defense will be arguing later on in this, that even if it meets the hearsay hurdle, you still have the confrontation clause. Just because it, according to this judge, is in preponderance of the evidence, blah, 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 and whatever. They still need this other hurdle, but the judge, no. They only need to get over this hurdle.
I'm curious to see what the state I'm curious to see what the defense argues with regard to the confrontation clause.
Yeah, it will show up later.
As such, 801 D2 Echo provides for vicarious admission in the context of a statement by a co-conspirator of a party, and that's found under State versus Martin.
Oh yeah, Ed, the guy who is making this jail call, he took an Alford plea, and that was overturned in the state Supreme Court in 2017. Then he took on a new plea deal in 2020. But this prosecution adds in the original one that was overturned. And in my opinion, if it's overturned, it is non-existent.
So these are statements being made by a defendant on a different case in an Albert plea that are being attributed to one of the defendants or all of the defendants here under some conspiracy BS.
Yeah.
Right?
Yeah.
Okay. So, I mean, the judge is technically right that actions or statements of a partner in a conspiracy can be attributed, but it would still fall under hearsay, and it violates the confrontation clause. So on two other grounds, it should be excluded.
Yeah, but not according to this judge.
And that is Ohio Case 9, Ohio Appeals 3rd 150. Now, to establish admissibility of an admission under 801 D2 Echo, the proponent must demonstrate by a preponderance of the evidence that a conspiracy existed. The conspiracy included the declarant and the party against whom the statement is being offered, and the statement was made during the course and in furtherance of the conspiracy. So we've had some discussion here about whether or not the conspiracy must be established. And you all are correct. It does need to be established. At this point in time, after hearing 70-something witnesses and the like, the state in the courts.
This has been the judge's ruling from day one. Now, after 70 witnesses, 5.5 months and 70 witnesses, now he claims for the first time that they have met that standard. But what about all the other, for 5.5 fucking months? This has been going on, and now he finds it? after allowing in absolute jack crap for 5.5 months. I'm saying unforced error from the judge.
Yeah, but they're going to have to get through the rest of the 2 years of this trial and then go to another 2 years of Court of Appeals.
Yeah.
It's just bad judging.
Yeah, they are 5.5 months in, 70 witnesses. The judge forced them to trim down at least, so they only have 209 witnesses. They aren't even halfway in the state's case in chief.
Opinion has established by preponderance of the evidence, at least for the purposes of co-conspirator statements, that that's been established. Now, whether or not the jury buys that is another thing. It's only for the purposes of admissibility in terms of whether or not the court's going to allow the statement. So that is the first thing that I wanted to share with you all this afternoon. Now, when offering the co-conspirator declarations, there's a burden on the state or the government to demonstrate the existence of a conspiracy, the defendant's membership in it, and the declarant conspirator was speaking in an effort to advance the conspiracy. As a rule, there must be cooperation of the defendant's participation in the conspiracy in cases where the government relies primarily on the declaration of a co-conspirator to show this element. So a party claiming a conspiracy must establish it by preponderance of the evidence. Our Georgia Supreme Court has remarked, we apply a liberal standard in determining whether a statement is made in furtherance of a conspiracy, and statements that further the...
Yeah, the Georgia Supreme Court can go eat my shorts. Applying a liberal, that is a very, very nice way to say, we want to get lazy prosecutions a bone.
Yeah, applying a liberal standard means they're opening up the rules to expand it beyond probably what was originally intended. So a lot of times the Court of Appeals or the Supreme Court will say, for this time only, or in these very limited circumstances, we're going to apply this rule. And then judges like this one say they're going to apply a liberal standard to it and expand it beyond what was originally intended.
Interests of the conspiracy in some way meet this standard, and that is Dover.
In some way meet this standard. Can you be more vague?
I should say Downer versus the state, 314 Georgia 617, and that is a 2022 case.
So they were arrested before.
And in furthering the conspiracy, a declaration must be made in furtherance of the conspiracy where the elements are proved. Courts are not reluctant to admit declarations of one conspirator as evidence against another. And then it has the, several federal courts apply a liberal standard in determining whether a statement is made in furtherance of conspiracy, including our 11th Circuit Court of Appeals. That's United States versus Steigman. It's SIEGELMAN, and that's 6-4. I'm sorry, wrong citation. I apologize. No, that's the same. It is Siegelman, and it's 640 F3rd 1159 11th Circuit 2011. And then statements which advance the objects of the conspiracy fall within the rule, and this has been held to even include statements of if uttered by an outsider, if the statement is designed to help the co-conspirators achieve their goal. So
an outsider. Yeah, but you still need to identify that outsider. That's the confrontation clause.
Part of what we've been discussing, or that has been objected to very vehemently on behalf of the defendants, but the court wanted you all to acknowledge, or the court wanted to acknowledge this, that at this point in time, this court is of the opinion that I'm sure over your objections that the state has in fact proved that there is a conspiracy by preponderance of the evidence at this point in time. And whether or not the jury believes that is another thing, but for the purposes of these statements, and I'll take them on an individual basis, of course, but those would be relative to what the court's considering this afternoon. So assuming that there's a foundation, which the court will
But you
continue to
still
look at,
have to get past the hearsay.
and assume.
Yeah,
I'm sorry, not the hearsay, the confrontation is what I meant.
exactly.
The
And
confrontation.
they will. Yeah, and the defense lawyers will talk about this soon. Yeah.
That depending upon what the state's offering the statement for, whether or not it's a statement against interest or a co-conspirator statement. I just wanted you all to know that that's where the court has studied and considered this particular issue, but we have taken it up about 3 or 4 times, and I just wanted to kind of make sure that you understood that. I understand where you all are, but understand that that's what the court's basing its ruling on. Mr. Steele, you want to add anything? Because we've covered your Mr. Winfrey's jail calls already, but
Yeah, hit
What else you wanna add?
the thumbs
Good
up,
afternoon, Your
folks.
Honor.
Good afternoon, sir.
Channels,
Everyone.
my little channel
2
really,
things. I know I
really
don't
needs it.
represent Mr. Huey or Mr. Nichols, but I presume that the state hasn't come close, this is how I look at it, to proving any type of conspiracy with them, but you included everyone, so I'm going to make the argument for everyone, but I just wanted to say that. In paragraph 51 of motion to limit number 51, paragraph number 4, excuse me.
without waiving objection,
One more time?
without waiving any objection, I'm looking at it right now. I have a copy of it.
Yes, sir. So what happens in those 2 minutes and 37 seconds of that call, October 22, 2015, it's not been played yet. State put us on notice of it, and I've objected to it on Friday when I got the state's 7 calls. This is not, so I don't know who the speaker is. So the speaker is clearly speaking with a person identified on the call as Mr. Winfrey. Mr. Winfrey's in custody, that's why the call's recorded.
Mhm.
The unknown speaker says, pursuant to another unknown person, Mr. Winfrey will receive a Porsche vehicle when he is released from custody. That's what I've objected to. So as you say, I don't disagree with anything the court said about the test. The declarant is not on the call. The declarant is an unknown person. The person on the call is unknown. So I don't know how that is a co-conspirator statement of a third party. It's double hearsay. That's what I wanted to bring to your attention in the motion limit number 51.
I'll let the state respond to that.
Wait, double hearsay?
Yeah,
So the unknown declarant makes a statement, and then the known other person on the other end of the line, who is supposedly the co-conspirator, affirms that statement.
no,
No? Okay.
he doesn't object or something towards it. So the
So it's not even even an affirmative adoption of the statement. That is
No.
double hearsay.
And this was 3 people in the call. All of a sudden, the 2 others starts discussion. What will happen later? Blah blah blah. Well, when Mr. Winfrey gets released, he will get a Porsche and $250,000. So the statement wasn't even to Mr. Winfrey; it was to the other unknown person.
Yeah, so this should not be admitted in any way, shape, or form.
But it is.
Well, a couple of days ago, in regards to non-party statements are admissible, and that was at 664 F 4th 396 in terms of these other parties or unknown parties that are speaking to provide context. So I understand that you're asking it's considered hearsay. I've considered that, but this would be an exception to that.
And the context is always like if the Honorable Mr. Matthews said to me, how much money do I bring to the drug deal? And my response was, bring $500. My response would make no sense unless Mr. Matthews
Sure.
is not involved in the conspiracy, he's working with the government or whatever.
Understand.
That would make sense. But here it is the person on the recording saying that another person, I don't know who these people are, Your Honor. Another person said that there'll be a Porsche vehicle given to Mr. Winfrey. So the context is really not anything here. The substance of the statement comes from a double hearsay declarant. That was why I brought it to your attention.
Okay.
Understanding, and honoring, but not waiving. That's why.
Yeah, I understand, because you're saying it's hearsay, and then the state's saying, well, it's not. It's an exception to that being a scope
They might say
conspiracy.
that, but we'd
Yeah,
like you
but
to
that's,
decide.
I'm sorry.
We'd like you to decide it.
Yes. Okay. All right. State.
Thank you, Your Honor. Your Honor, consistent with what the court just spoke about regarding the law and co-conspirator, this particular statement is furthering.
Which one? Be specific. Which one are you talking
The
about?
statement
Winfrey
that-
phone calls
the
or
Winfrey phone
or the Instagram?
No, we'll talk about the Winfrey phone calls first, Your Honor.
Okay,
The
all right.
Winfrey call, which is this call that's about 2 minutes, in which the declarant is an unidentified co-conspirator, because in that statement, what did the
Unidentified co-conspirator. I mean,
this is so this is clearly a bad judge. Gigi had a good question. She's like, could these defense attorneys be doing more, or is this just a sign of a bad judge? I mean, everything that I've heard from the defense is really good arguments, legitimate arguments, outstanding arguments. And when you're up against a bad judge, you're just sort of stuck with it. But they're doing everything, it sounds like, that they could be doing. Except I don't know if they've asked for an interlocutory appeal at all. Okay.
And the judge will not release it. So they have to wait till the end of the trial.
Yeah, so that's the only other thing. The one last thing, and I don't know if that's available in Georgia at this particular stage, would be a writ of mandamus, which would be going to the Court of Appeals to ask them to order this trial judge to do something specific. So you don't need permission to do that. You just go to the Court of Appeals. But I don't know if that's available.
I have a slight recollection of something like that happening back in January or something. Or if it was just the threat of one, I don't remember. This trial is long.
Yeah, no, 70 witnesses so far. I was shocked by that number.
Yeah, we are on day 70, trial day 76, and 70 witnesses. Yeah, and this is after the judge told them to trim this down. Now, this particular thing they are talking about now, it is under the RICO charge. It is a bus shooting. Somebody shot at Lil Wayne's tour bus. So far, they have had 9 witnesses about this. 4 of them have talked about the bullets. The one that is currently on the stand is a cop, the so-called lead investigator. He's now who have testified about phone towers, and then they will also call a phone tower expert to the stand. So this is after the judge told the prosecution, trim it down to only the necessary witnesses.
Well, okay, so here, you watch trials of like serial killers, say, for example, and they only tried them for, say, 2 murders, even though they're suspected and alleged to have committed 9, right? The reason why you only bring a small number of murders is you bring your strongest ones and you get a conviction because you know they're going to get life or a substantial amount. You can always try them for the other ones later if you want, but otherwise you're looking at, a 2-year-long trial with thousands of witnesses, and it doesn't make sense when that's not what you need. So the first problem with this case is they're going way too far to try to attribute too many different criminal acts against these defendants, and they're charging too many defendants all at once. So it just makes it a really confusing, really long, and really jumbled. Then the other thing is that if they have to bring this many witnesses to prove a conspiracy, I doubt that there's a conspiracy. I mean, because, there was 6 degrees of Kevin Bacon, right? We could prove that everyone's connected on social media by like 3 people. Well, how many witnesses do you need to prove that in order to make it true, right? You have to call a lot of little tidbitty witnesses to do all this. It's a fairly weak connection.
Yeah, and I mean, nobody has denied that these guys know each other. And this is one of the really high crime area, extremely poverty-stricken area of Atlanta. There will be crimes. There will be gangs.
But let's say, for example, the bus shooting, right? Was anybody killed in the bus shooting?
Nope.
Okay. So, but let's just say the evidence is strong that the bus shooting and the bullets tie back to one particular person. They can connect the dots and say that this was a conspiracy, a gang of some sort under the RICO Act. Fine, just charge the bus thing. Don't charge the other shootings. Don't charge the car accident. Don't charge all these other things. But they have to, because the connection between these people is so tenuous that they have to create this huge, elaborate web just for anything to stick. And that's the problem with this case.
Yeah. And under the RICO charge in this case, they have 196 underlying acts and overt acts.
Yeah, this is just way too much. They bit off way more than they can chew. They're trying to eat the whole elephant in one bite, and it's just impossible.
Well, they got, I mean, they were 28 defendants to start with. They are down to 6. So there's a bunch of people who took plea deals. A handful of them have to testify in this trial. But for instance, the guy who took the Alford plea in this 2015 bus shooting, who was then, the plea deal was then overturned by the appellate court because it was coerced. Then he took a new plea deal in 2020. And he's already
Is
punished
this guy
for this.
missing? Can he be called as a defense witness? Or
the state won't call him. He's
well,
not
you
on
know,
their
the
witness
easy
list.
fix I would recommend to the judge, if I'm defense counsel, the easy fix, judge, would be the state can call this guy to the stand.
Here's the thing. The judge don't care. They get all of this in through the lead investigator. The plea deal is entered through this lead investigator.
Is he the one on the phone call? If he's not the one on the phone call, how does he even have foundation to admit the? This is all kinds of nonsense.
Oh, but you must understand, Dave. This lead investigators, he pulled that jail call.
So he knows the defendant intimately enough to recognize the voice. This is all stupid.
Apparently, Atlanta, Fulton County Jail, you have to press in your jail number.
Oh, you have to identify yourself.
Yeah.
Okay.
So, but let's keep going.
All right.
Clarence
This
says
is all
that,
stupid.
We'll sit down for $250,000 in a Porsche. And Mr. Winfrey doesn't say no. He doesn't say anything. He says, okay, that's my boy. That's my boy. My boy ain't never changed. And so, Your Honor, that statement is furthering the conspiracy as far as concealing what occurred in the conspiracy, which is we will sit down. We will be quiet. We will not say anything for this amount of money.
Whatever
whether or not
his name
that
is,
happened or not,
never
whether or not
got a
he got paid,
Porsche
whether or
or
not he
money.
got a Porsche is of no consequence. But this conversation here shows that there's a covering up of the conspiracy, that conspiracy being 1, the gang, and conspiracy 2 being the actual shooting of the bus, Your Honor. And so we believe that this would fall under the co-conspirator hearsay exception.
Are you going to identify the speakers on the?
For you who are completely new, they tried back in 2015 to connect Mr. Stilwell and Mr. Williams to this bus shooting. But no, they not even charges, because Mr. Williams was 600 miles away doing a concert at the time. And Mr. Stilwell was somewhere. They couldn't say, there's no phone call, no nothing about this that actually connects. But in a jail call, some unknown person says, well, you will get money and a car. And anybody can say shit on a phone.
On the call?
We'll identify Mr. Winfrey. I believe this is the person he's speaking to is Shad, who is mentioned in other calls as well.
All right. Okay.
But that's the only identifier that we know his name is Shad.
All right. Sir, Mr. Harvey.
I want to make sure we're making the appropriate distinctions here with regard to, and I understand the court's ruling, but I want to make sure that I get on record. but I think are critical distinctions. Let's go back to when the court said, state, give us all your 801D2E statements that you're going to use during the trial of the, so that we can take these issues up now and not during the trial, just like we're doing. So number one, I do want to say that these alleged 801D2E, and I'm not agreeing that they are, statements that are now.
Mickey Jones says in the chat, that jail call was under someone else's PIN number. So how the fuck did they find it and attributed it to Mr. Winfrey?
Well, because he knows his voice intimately.
Yeah. That knows his voice intimately is like a cop driving down the highway and can smell pot on the car 3 cars down.
But he said it, Nick, therefore it must be true, because he's an officer and would never lie.
Yeah, it's like Detective Velasquez, who 4 months ago admitted on the stand under oath that he tampered with evidence. When he takes testimony from witnesses or statements from witnesses, if he doesn't like their answer, he erases the recording until he gets an answer he believes is truthful, and thereby denying the defense the opportunity to actually check what was going on. So yeah, do I have any? Yeah, I don't trust cops in Atlanta.
Now being proffered were not provided to us, and we didn't have an opportunity to litigate them pre-trial. And now we're doing exactly what the court didn't want us to do, number one. Number two, we're also talking about a confrontation clause problem, because we have, for example, the pleas of guilty, admissions by co-defendants that are coming in that we cannot cross-examine. For example, precisely the ones that we are talking about now. Mr. Murphy, we know that beyond the hearsay argument, Judge, there is a confrontation clause argument.
Have you taken a look at U.S. versus Thompson? That is, that is 568 F.
And
listen to this judge just shooting out there. Won't you take a look at this case? You don't have a right to confront witnesses.
Yeah, and he allows the prosecution to just spill out whatever they want. But as soon as a defense attorney tries to make a good argument from point A to point B, here is why my argument is good, he interrupts them every damn time.
I haven't looked at that case, but I guarantee it doesn't apply to this situation. I guarantee it applies to some weird little ancillary thing about a minor not wanting a minor to testify in an open court regarding a domestic violence assault or something stupid like that. And he's going to use it, though, in this context.
Let's see here. US
I might be wrong, but I'm guessing.
Let's see here.
Like a statement to medical personnel after a child was violently assaulted by somebody. Something like that. It's got to be something like that.
Yeah, I'll send you the US v. Thompson via the Twitter.
Okay.
Because I don't have the time.
Well, and I'm driving, so it might be a tomorrow thing.
Yeah.
PPX 812 11th Circuit 2014. And it talks about the right of a defendant to confront accusers. Thompson seems to indicate no, but I understand your point. I understand your point. I do.
But there is an 801D2E right of confrontation. There's an admission of a co-conspirator, an admission of theirs or a confession of theirs that we can't confront, that presents a different problem, like a plea of guilty. We argued that with regard to Jefferson, and I think Jefferson versus the state is clear. So I want to make the distinction. State versus Jefferson. And I want to make the distinction, because it comes in under a hearsay exception does not resolve the confrontation issue. And Mr. Nichols does not waive that confrontation issue, even if you find that it's a
But
co-conspirator
801
statement.
D2E statements are not considered to be hearsay. They're not.
I understand.
Okay, I just want to clarify, that's all.
I understand
Okay,
that. You,
all right.
and I want to make the distinction that because it comes in, there is a class of evidence that comes in under 801 D2E. There's a class of evidence that comes in as admissions of party opponents. Those are subject to the confrontation clause, and we need to make that distinction.
Okay, and when I charge the jury, when I get down to that, yes, that will be a jury charge that I will probably need to hash out, but at this point in time.
So he's going to let everything in and then do a jury instruction. I mean, the stupidity in this.
They're admissible for, as a threshold matter, and the jury can weigh them as they see fit.
Okay, well, admissions, I don't think are admissible at this particular point against Mr. Nichols.
Okay, but that's your
Yes, and I want to make sure
that is your position at this point in time, and that has not
that's right.
changed. And I certainly acknowledge that, sir, and will continue to mark that objection for you.
All right, thank you.
Okay, all right. Unless there's anything else, I'm gonna call for our jurors. Okay.
No, I was gonna say, in relation to the hearsay statements on the Instagram records, Your Honor, the state did redact any of the commentary that was on the bottom. We did keep what we believe Mr. Williams would have posted himself because it's his Instagram, but the commentary that's on below that we did redact, and I can show that to Mr. Steele prior to
All right.
that being. And I can show it to him now.
Do you want to show it to him now then?
Yes, Your Honor.
Okay.
Your Honor,
Sir.
did you rule upon paragraph 4 of Mr. Williams' motion limiting number 51? What I just argued about the portion?
I'm going to overrule your objection, sir.
I just have it continuing.
Yes, you may have a continuing objection. Absolutely.
Thank you.
All right, you want to take a look at these Instagram postings?
Yeah, and it's all coming in because he believes the jury needs to hear him, and then they can hash it out. Now, this asshole talks, and he gets questions about the specific plea deal that was overturned due to coercion by the appellate court. The defense argues, well, since they asked about this 2016 plea deal, we should be allowed to ask him about and bring up that it was overturned because of coercion. So let's get ahead to that part, because this guy is, oh, by the way, we have a sidebar. And what happens at sidebars? Folks, you know exactly what happens. It is sidebar counter 175.
I was engrossed in driving and trying to read a case. I'm going to probably avoid reading the case right now.
Yeah. Yeah. And then they had a break, and let's see here, because the testimony is
Everybody here?
No, we're good.
Everybody here?
Yes.
All right, Sergeant Brown, is everybody here supposed to seated? I'll note for purpose of record, Mr. Sharp wishes to be excused. Mr. Botch, you have the con, so to speak. Mr. Stillwell, that's okay with you, sir? Okay, all right.
I'm in Kentucky, by the way.
yeah, you're on your way to Nashville, aren't you?
Knoxville, and
Knoxville, yeah.
I just entered Kentucky.
Yay!
Finally got out of Ohio.
And our witness?
stopped at the wrong moment here. He talks more. Oh, look at this and look at that.
Correct. So
and
we're on that same vibe.
stupid. And we have another sidebar. Which brings us to sidebar counter 176. Hit the like
that's
button,
awesome.
folks. Hit the thumbs up. I deserve it.
Just for the laughs.
Ladies and gentlemen, we have reached a natural stopping point for the day. That's just when anybody except the attorneys in this case. Please do not discuss your experiences thus far in any way, shape, or form. Continue patience.
Now let's hear.
Ladies and gentlemen, please be seated. All right. Ladies and gentlemen, any other minister inquiry me, so not I'll release you for till tomorrow morning.
I don't have can I make a motion and just let me know if I can do this tomorrow so I don't waste the time. Is that okay? Not waste the time, but take up your time.
What motion do you wish to make, sir?
So I made it at the bench. The state asked Agent Racy whether Mr. Winfrey pled guilty shortly after the October phone call that was played over objection, where he was, where an unknown person states another unknown person stated he would get a Porsche.
Yeah, we covered that already. So what's the, you have an additional objection, sir?
Yeah, so this is my issue. So the state said, did he plead guilty? Knowing, and
But we covered that, Mr. Steele. We covered that. So what's the additional ruling on it?
knowing that that was not a guilty plea. That was a coerced guilty plea is not a guilty plea.
But we had a discussion at the bench, and I told you that you can inquire into that depending upon what was testified to.
And I'm going to do that, I propose, but my point is that was so low blow to say a month later, a man who was coerced by a Superior Court judge in Cobb County pled guilty, that I don't know if I can overcome that, because the impression is that Mr. Winfrey was being rewarded for his guilty plea. The state knows that guilty plea was not.
But we don't know as I mentioned earlier, the bench, we don't know the circumstances of why that particular first guilty plea was rejected. I don't think it's relevant for our purposes. I think the state said they weren't going to get into it. So again, the second time, because we covered that up at the bench, do you have anything else you wish to add to that? I don't think the state was trying to.
The fact that the very statement being offered was considered coercive by the Court of Appeals is not relevant? Okay, Jay.
Yeah. Yeah. I mean, it's, I have no, and I don't know what to say. The judge, as you said, Dave, the judge claims that the appeals court decision to overturn a plea deal because of coercion, this judge says is irrelevant. In that, he allows the prosecution everything.
Test that or reason, because it might go to bias, it might go to motive to misrepresent. So
it bothers me a great deal, and I'm surprised, but I'm not ever in the mind of the court. It doesn't bother the court because it doesn't go to bias, and the state knows exactly what they did. They know, and you know.
I don't. The first time that I knew that there was an appellate opinion is when you told me, and that's it. I don't have any other knowledge of that.
Well, I read under opinion, and Winfrey versus State specifically states, and it gives what happened, that the Honorable Judge Staley in Cobb County coerced a human being to enter a guilty plea. For the state of Georgia to say, did he plead guilty a month later? That to me is beyond the pale. And I would like the court to.
I think that's just them asking. They're not asking why, which would be improper. But because it gets into evidence that would be not relevant for this particular proceeding.
I'm like so twisted in my mind. I might be tired, but I don't follow. It should have never come in. It did come in. Now I have to deal with it. You tell me I'm cross. And
I don't think you're conflating, Mr. Steele, the bottom line basis as to why the initial guilty plea was rejected by our appellate court. I'm telling you that I don't know what the basis of that. I still don't know because I didn't read the opinion. The state didn't solicit that or elicit it from the witness. They only just said, hey, he pled guilty on another thing a month later. But the relevant portion that the court heard was the fact that if the jury wants to believe it, is the why as to what Mr. Winfrey may or may not have gotten. And that's the only thing that I heard at this point in time.
I think that, you know, from being a person who loves what we do and loves the courts, I think it's offensive to say and have an agent testify that a guilty plea occurred when everybody knows or should know that that guilty plea is not a guilty plea, it is struck, vacated.
Okay, and Mr. Steele, I'm kind of just telling you that the reason and rationale is not, that would be totally improper for us to get into.
Okay.
I would agree about that, but I don't think that was the state's intention in asking that question. So I'll note
Bullshit.
your concern for purposes of the record, okay?
Judge Spineless Glanville, you know damn well, because the prosecution does this on a daily basis, and you allow it.
Okay, so I'm going to make a proffer then for about 10 seconds if I may. And I understand what you said. Of course, I'll follow your rule. But I was going to ask Agent Racy, I was going to take the opinion, and I would be perfect to the opinion. And you stated that this man pled guilty. The man actually wanted to go to trial. You can say yes or no. The man was then told by Judge Staley that she doesn't see him winning. She knows the people in Cobb County, they will not like him. He will go to prison. He's going to be sentenced for X number of years, whatever the opinion says, and then he can answer the questions. And I will then ask the court to strike that testimony again, like I did earlier. I understand you're telling me it's not relevant. I believe that it should never come in the first place, and the state of Georgia has misled the jury. He did not plead guilty a month later because we do not recognize that as guilty. When I say we, you know, our system of what we call just was not, it was perverted.
Okay, all right. State, hold on, Mr. Matthews. The state wish to be heard on that issue?
Yes, Your Honor.
Yes, Ms. Hilton.
Your Honor, first I want to direct the court to an order that was entered on April 9, 2024, in which there was an order in which we cannot discuss the appellate process. What is a fact is that Mr. Winfrey pled a month later. What the state asked, which was my next question, for, and I forget how I phrased the question, did he have to plead again and plead again to the same charges? And he said, yes, approximately a year later, to show that there was something that occurred and he had to plead again. But the fact remained that 1 month later, he took a plea. Now, the reason why it was overturned, or the reason why, that is the appellate process in which the court has ordered that we cannot discuss and that we cannot get into. What Mr. Steele is speaking of is,
I mean, the absolute shadiness. The reason you can't discuss the appellate is to not influence the jury to make a ruling because there is an appellate thing. That is what that was about. Not about you saying, well, did he plead guilty? Yeah. Did he plead guilty again? Yeah. And now because now they are bastardizing that ruling into this prosecution is so corrupt, and this judge has no spine.
the reason why it was overturned. That is not for this jury to determine. They can know he pled once and then he had to plead again, which is the plea that we had. Because what I can imagine is on cross-examination, if I did not ask that question, they would have crossed him on it. And so what I did was ask him about a fact, which was a fact. Which was a fact. And then did something else.
No, it's not a fact because it was overturned. Once it's overturned, it is non-existent. It never happened in the eyes of the justice system. If a plea deal is overturned, it is wiped out. It doesn't exist. But
occur later on, which is also a fact. And if Mr. Steele is going to go into what occurred during the appellate process, he's going to be assuming facts, not in evidence, because that we never asked him anything about the appellate process.
When did I enter that order?
On April 9, 2024.
Okay, all right. So I've already dealt with that issue, Mr. Steele. I note your objection, so I don't believe that those questions would be relevant for this inquiry based upon my order. So,
Sorry, I had to
but I'll
disappear
note your
for a
objection
second.
for the record, okay?
No,
All right.
I appreciate your kindness. Can I have 2 more statements for this, if you don't mind? I understand the ruling, I just want to make 2 more statements.
Yes.
Okay, thanks. First one is, I don't know how the state can say I was going to, or anyone, maybe I shouldn't speak for other people. I never had a conversation with the prosecution that I would ever cross-examine a witness on a coerced guilty plea.
You made a proffer, that's all. I mean, I don't think we need to spend more time with it, but
Well,
I'm good.
They took the wind out of the sails. I never, ever was going to do that. Number two, based upon your ruling, I understand it. And I just like you to, I'm going to move for a mistrial because I can't cross it. If it's denied, can you just do what I've been doing? Just.
I'll deny the motion for mistrial. I'll go ahead and grant you, I will note that you've asked again for mistrial before the positing of the next question, which you've done. All right, Mr. Matthews, did you have something you wanted to
Yes,
tell?
sir. I just wanted to chime in on that issue that has just been addressed by the court. I wanted to.
Which issue, sir?
That the Honorable Mr. Steele addressed with the court.
Which one?
regarding the guilty plea.
Okay.
Or lack thereof.
Okay,
So essentially, Your Honor, when the state had Agent Racy on the stand, they started with the jail call. They played the jail call, give you a Porsche and a $250,000. Then they identified this person's shot. What did you hear him say? Heard a $250,000 Porsche purchase. What was significant about that call? And then, Your Honor, the state said, now then a month later, the Jimmy Winfrey plead guilty. In the testimony, the response was he pled. Mr. Steele made an ask to approach. We approached. He made his points at the bench. After he approached, that's when the state furthered their question and said, hey, did something occur a year later? And did he take another plea? So that was afterwards. So in my mind, Your Honor, that sequence of questioning about the prosecution led the jury to assume and conclude that it was after he heard $250,000, after he heard that a Porsche was going to be given to him, he pled a month later. And I don't think we can unring that. And again, the Winfrey versus State 304 Georgia 94, what Mr. Steele is saying, which I tend to agree with, is that after that Supreme Court reversed that plea, it was not a plea. It was not a guilty plea on that date when he initially pled a month later, because it was reversed, and it was reversed because the Supreme
Nick,
Court.
do you have other trials from this judge?
The judge.
So what to say?
Do you have video of any other trials that this judge has presided over? Have you looked at any of those?
I don't, but I do know local lawyers say they don't recognize this judge in this trial.
That's
And,
what I was wondering. Like, is he just extremely overwhelmed with this particular case? Is he always like this?
I think that because this judge has PTSD, he has a dog behind the desk. What do you call it?
Oh, like a companion dog or a mental health dog or whatever?
Yeah,
Emotional support animal. That's what it is.
Emotional support dog behind there. So yes, I do believe that everything, because this case didn't, I mean, the pre-trial in this case started in 2022, the pre-trial, and then it took up until November 28th of last year. That was the first trial day. That was after 10.5 months of trying to find a jury and pre-trial. So yeah, I do believe Judge Glanville is completely shut. He is so overwhelmed, and he should recognize.
You know, he could pass this case to another judge. He could recuse himself, as I believe the defense has asked him to do, and he could be done with it. I'm wondering if there's internal pressures to, like, no, you're keeping this case.
He is the chief judge. What would it look like in the next election if he passes on a RICO case?
He's the chief judge? Oh my God. Okay.
Yeah. And that is what makes me worried about it. I mean, this trial will last another year. And if the jury comes back with a guilty plea, we are talking about at least 3 years before they even approach the appellate court, because every piece of evidence, I mean, imagine the cost of the transcript alone from this trial.
Oh, it's ridiculous. This is day 68 or 69, you said? It's ridiculous.
This is trial day 76.
Trial day 76.
Yeah. So they actually only had 76 trial days in 5.5 months. So
now, put yourself in the defendant's position, right? You are the defendant. You are being accused of a crime, and they're going to spend 76 days trying you, to date. And then when you want to appeal, assuming you get convicted, you're going to have to front the bill for that. It's cost prohibitive.
Yeah.
Properly under Uniform Rules of Superior Court of 33.5 paragraph A determined that she improperly involved herself in plea negotiations, and there are a number of quotes, this opportunity is going away.
Okay, what does that have to do with the issue of what was just presented? I get it. The guilty plea was faulty for whatever reason.
And the state
And-
knew that, and they had a responsibility to know that. This is their.
But we covered that on order on the 9th. We covered that at the bench. Mr. Steele already went through it. Do you have anything new you want to tell me?
Just that they, on the 9th, the state knew that. They knew that before they asked that question this morning.
Anything else, sir?
So I'm intimating to the court that that door has been open in our estimation. The court will have to rule on it.
I don't believe that door has been open. I believe that at this point in time, it's going to stay closed. Okay, but I'll know your.
This judge, did you hear how offended he became with them claiming that the state opened the door? I mean,
Yeah, he's just finding every possible reason to allow this video in or this audio recording in. At the end of the day, you have to realize that whether you're a trial judge like this guy or you're a Supreme Court justice, once you've made a decision, you can argue your way to support that decision. This judge has already made the decision, and he is going to offer an opinion and justification for it, no matter how ridiculous it is. He's not going to change his mind.
Yeah. Now, that was the last thing that happened on day 76. Now we are going into today, day 77. So,
Nice. Well, I am driving through a storm through the hills, so I think I'm going to jump off. My phone is almost dead, but I'll be jumping around in the chat.
Yep, do so. Thank you for being here.
No, take care. Bye.
Take care. Bye. Yeah, and for you who don't know, Dave is a lawyer. He is a trial lawyer. He does criminal defense work and some civil cases in Michigan. So yeah. So it's not just me. It's not just me. Now, day 77 started with a sidebar. Which brings us to sidebar counter 177. And hit that thumbs up, folks. Jesus Christ, it's not that hard. There's 120 of you here. There's more than 120, and only 50 thumbs up. We need to double that. 50 of you, hit that thumbs up.
Our juror is, but before our jurors all have been accounted for, and then we can bring them out. I don't know what our ETA on our juror is, but I'll find that out in just a minute. Anything I need to take
the
up
juror
with
was late.
Mr. Steele.
Good morning, Your Honor. Good
Sir.
morning to everyone. Your Honor, I just wanted to reintroduce you. I've been reporting to them. This is a coworker of mine who's finished her, coworker who's finished her second year going to third year at Georgia State University. This is Haley, H-A-L-Y, Halter-Wenger, H-A-L-T-I, W-A-N-G-E-R, and she'll be with us a great deal, I hope, this summer. And then, Your Honor, she's accepted a position as an intern for credit with the County Public Defender's Office starting in September. Unless the court has an issue by the ask respectfully. She has and she'll be a role that school.
Is she replacing Mr. Kokomo?
No.
Oh, could you please replace him? I mean, madam, I can give you carte blanche if you'll just take over from him, okay? She's been a problem. So, madam, welcome, and I hope, yes, she is, Haley, you are more than welcome. And hope you embrace the experience, okay?
And please write your thesis. at the end of this, when you take your bachelor's, about this absolute clusterfuck of a trial.
All right, anything else? All right, anybody else on anything we are covering and that we're gonna cover? All right, and hearing nothing at this point in time, then what I'll do is I'll just recess this. Do we have any updates, Sergeant Brown, on all of our jurors? Okay, all right, we'll be in recess, and then I'll give you all an update on our jurors.
They are in recess because a juror is late. Of course. I sped through yesterday. Now, I didn't speed through it because that was the only thing of actual interest, because the cop on the stand, the lead detective, I've been covering this trial for 5.5 months. I started covering this case in May of last year. So I've been on this for a year now, this case. This is that detective, I don't care, was probably the single most boring person on the stand thus far. Absolute cluster F. Absolute cluster F. Now, okay, I will set up a poll. Oh. Thank you for your super chat, Sarah. Says Judge Glanville is up for re-election in a few days on May 21st. Judges need endorsement from the DA's office. Maybe he will change after Tuesday's election. I doubt it, because after Tuesday's election, he must still oblige by his previous rulings. He can't just turn around and say, aha, just kidding. Psyched. Thank you so much, Sarah Pearson. Thank you so much. The occasional super chat and membership, that is what keeps this channel afloat. Now, I asked in the, I have a poll up. Do you want to hear a Scandinavian fairy tale while we wait? For you who don't know, I have a secondary channel where I read those things. And the latest is called The Princess on the Glass Hill. Hey, Dave. Member for 1 month. Only been a member for 1 month. Seems longer. Yes, Dave. That might be because you got your other channel cheated. Oh, thank you for your support. And if anybody else is thinking about becoming a member, it's $3 a month. And you get access to all my members-only content. Mickey Jones says, my lawyer, who used to be a judge for 29 years, says this case is going to be overturned so fast your head will spin. And he is in Miami, Florida. He said, this is so biased, a blind judge will say it. I agree with the bias and everything, but this is the chief judge. For an appellate court or a Supreme Court to overturn this, remember, he quoted the Supreme Court, the appellate court, in order to get absolute jack shit in testimony and evidence. So I'm not so sure, because it seems like this kind of liberal interpretation of the rules is supported by the Georgia Supreme Court and the appellate courts in Georgia. And hello over at Rumble. Yes, I'm streaming over at Rumble today. Let's see here. Still nothing in the courtroom. Still waiting. Still waiting. Yes, I have. Let's see here. Thank you, Gigi, for giving the link to my secondary channel. It's a very even vote so far. But so we can still wait. What can I do meanwhile? I can see if I can find some dirt on Fannie Willis while we wait. Hold on a second. Let's see here. Oh yeah, this happened a week ago. Let's see here. While we wait, okay. Dun 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 dun. Georgia's State Court of Appeal said Wednesday it will consider an appeal from former president challenging the decision not to disqualify Fannie Willis as the district attorney overseeing the 2020 interference charges against him. The order said former president can file a notice of appeal within the next 10 days. A lawyer for former president, Steve N.Starow, said in a statement that former president looks forward to arguing before the appeals court that the case should be dismissed and that Willis should be disqualified for her misconduct in this unjustified, unwarranted political persecution. The DA's office declined to comment. Now, this disqualification thing is through a co-defendant in that case. And I assume former president didn't join that disqualification thing until quite late. So that will, I assume that it will be going through Miss Wathers, the lawyer who has been arguing towards Georgia Senate and so on. I still haven't seen any updates about it, but since they asked, and well, since they asked for it, they will probably appeal. And this because Mr. Nathan Wade went out to give an interview a couple of days ago, where he contradicted what he said on the stand. So, in my opinion, Fannie Willis, she lied in church. She falsified records on behalf of Mr. Wade. She's a hussy. She slept with a married man knowing he was married. Gave her boyfriend a position he had no business having. Still nothing from the state. Okay. The vote has been up for 7 minutes. And it's a 60% yes. Now, this is quite it's not a long fairy tale. It's, let's see here. I have to find it. see here. I will take one that is. No, I will actually, because we will catch up on this trial anyway. So I will. Let's see here. Bum, bum, bum. Dun 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 dun. All right. All right, let's listen. Hello and welcome to Scandinavian folk tales, sagas, and fairy tales. I am the Elder Man, and today I'm going to read The Princess on the Glass Hill. Once upon a time, there was a man who had a meadow, which lay on the side of a mountain, and in the meadow there was a barn in which he stored hay. But there has not been much hay in the barn for the last 2 years. For every St. John's Eve, when the grass was in the height of its vigor, it was all eaten clean up, just as if a whole flock of sheep have gnawed it down to the ground during the night. This happened once, and it happened twice, but then the man got tired of losing his crop and said to his son, he had 3 of them, and the third was called Cinderlad, that one of them must go sleep in the barn on St. John's night, for it was absurd to let the grass be eaten up again, blade and stalk, as it had been the last 2 years. And the one who went to watch must keep a sharp lookout, the man said. The elder son was quite willing to go to the meadow. He would watch the grass, he said, and he would do it so well that neither man nor beast, nor even the demon himself should have any of it. So when evening came, he went to the barn and lay down to sleep. But when the night was drawing near, there was such a rumbling and such an earthquake that the walls and roof shook again, and the lad jumped up and took to his heels as fast as he could, and he never even looked back. And the barn remained empty that year, just as it has been for the And it started! And it started. I have my secondary channel listed on the top of the chat if you want to hear the rest of that story.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. Ladies and gentlemen, jury, good morning. All right, still morning. All right. Okay, ladies and gentlemen, we're going to continue with our current witness. Agent Racy, you're still under oath, okay?
Yes, Your Honor.
All right, may continue.
Thank you, Your Honor.
The world's most boring person. And thank you, Slidey Pie over at Rumble, for your $2 Rumble rant.
Agent Racy, good morning.
Good morning.
When we left off, we were going through the actual location of the cell towers based upon what we charted out yesterday. First, when you plotted these locations, is the correct time not the 7:07 but 3:07 a.m.?
Correct. The Eastern Standard Time is the 3:07, correct.
Okay. And so on the diagram that's currently on the screen at the top where it says 7:07, would you -4 from that number?
Correct. That's the UTC time displayed from the records.
Okay. Now, looking at what's on the screen, if you can explain to the jury based upon the map where this cell tower is located.
Okay, so this road that's
Remember, folks, they have an actual cell tower expert that is going to testify later about these exact same things.
Running straight up through there.
that we can see that kind of gray line right there. That's gonna be Marietta Street changing into Atlanta Road into Cobb County. Right around here is the compound area, and of course, that's 285 going around there like northbound.
Okay. Now looking at the next plot. And again, looking at what's currently on the screen, this is State's Exhibit 172, Echo. What time is this plot?
So it's displaying 7:14 UTC, so that's 3:14 Eastern Standard Time.
And where is the cell tower located?
So the cell tower is gonna be 285, right before 75. I described it, I believe, yesterday, kind of where the new Battery Braves Stadium is, kind of in that little area there for reference.
All right. And again, at what time did the 911 call come in?
The 911 call came at 3:14.
So would that be 3 minutes before this? Excuse me, at 3:14.
That's at 3:14. So the 911 call is coming in the records at the same time that this phone is connecting and communicating with that tower.
Okay. And what number is being contacted at, what number is the 1990 number contacting at 3:14?
It's the 404-664-3383, which subscriber information tells us is Jimmy Winfrey.
Now, looking at what we looking at what we charted out.
How
2
on
days
earth am I
ago.
going to make this entertaining?
Do you see a corresponding call to 1990 on this chart?
Yes, that's gonna be on line number 5, but it matches for the 3:14 domesticated for Eastern Standard Time. That phone was at 285 near 75. We described it between Atlanta Road and 75 on 285 and communicating with the 1990, the YSL Enterprise phone.
And again, when you are talking about the location, is that the location of the cell tower?
That is correct.
Right. So at this 3:14 time, both the 3883 number is pinging on a cell tower in the area of 285 and I-75, as well as the 1990 number.
I sustain the objections. You can rephrase now.
Yes, Your Honor, thank you. At 3:14, are both the 1990 number and the 285 number pinging off towers in the same area?
The 1990 YSL phone and the 3383 phone are both communicating with a tower in the same general area next to 285 or near 285.
And, all right, now looking at number.
And she has scribbles on Jesus Christ. Seriously? I am not a biggest fan of PowerPoint presentations, but that would have been easier than that piece of. It looks like that conspiracy guy meme made a doodle.
13.
Yes.
What, looking at the map, what is depicted on the map as relates to line number 13?
Correct. It needs to move up like it. Thank you. Okay. So what we see here, it's 7:15, which is UTC. So subtract 4. It's 3:15 in the morning. So a minute later, and we're seeing a new cell tower being communicated with the 1990 YSL Enterprise phone. And that cell tower is still on 285. It's just further up towards that next, I think I called it Northside Drive, I think is the next exit. It's been a few years since I've been in Atlanta, but I believe that's the next exit. So just closer in that direction is the way I described it yesterday.
Okay. Now, looking at 715.
Now she has to turn the pages back and forth because she's jumping in between the Jesus Christ.
When do you see a call on the 1990 chart at 317?
Yes, we do see one represented, yes.
And looking at the 317 time, where was that cell tower located?
So if we recall, this is the Sprint cell phone records. So the way Sprint represents it is a first tower connected to and a last tower connected to. So we have two towers represented in those records. So at 317, the first location is what I described, 75 South, basically in the city. So it basically is on I-75 South in the city. And then the last tower communicated with, we had the communication down in this area near Metropolitan Avenue for that duration of that call, first cell tower, last cell tower.
So based on the tower location, so the 1990 phone at 317 is still, the tower is on 285.
Correct.
Okay.
1990 is continuing on a tower on 285 northbound towards Roswell, Sandy Springs area. And our 3383 number is basically on 75 South, leaving Cobb County.
Now, looking at this map, are you able to tell the direction based upon the 911 call where the bus was traveling?
Yes, based off the 911 phone call, we do have a description of the way the bus was traveling.
Can you show the jury where the bus or how the bus was traveling based upon the 911 call?
Maybe some background music will help.
And going north and then eastern direction and then south on 400.
And if you can show that route on here.
Sure. So here's Atlanta Road getting on 285 north, past 75, continuing to 400. I'm sorry, there's 400. 400 south towards the Mandarin Oriental Hotel.
Okay. And from the 911 call, do you recall when he called 911, where was he at when he called 911?
So in the 911 call, the description is 285 on basically 285 traveling northeast. There was basically some trouble because the person didn't know Atlanta. But through the description on the call, we understand that they were approaching Cobb Park.
Basis.
Your Honor, the 911 call is in evidence.
I'm gonna rule the objection, sir.
What did he say on the 911?
And the speculation.
What did he say on the,
Basis.
sorry, Your Honor, what did he say on the 911 call?
They're on 285. We hear coming up to Cobb Parkway, and we hear the description of I-75 in the 911 phone call.
Okay, where's that?
So again, 285, Cobb Parkway, 75. So traveling that same direction, that northern direction on 285.
And I'm sorry, you're gonna stand one more time for him, at least right now. Can you see the general area of where the Mandarin Hotel is on this map?
So it's going to be kind of down in this area right around here. I'd have to zoom in to look at the roads to be 100% exact. Just generally that area there is where in Buckhead is where the Mandarin Hotel is.
All right. Now looking at number 14. What is depicted on the map with number 14?
Sure. So again, we see a change in the cell tower location just a little bit further on 285. And I describe it as Roswell Road. I believe that's the next road on 285 going now that eastern, kind of northeastern direction. But it's just, as we saw, it just moved a little bit further up the road.
All right. Now looking at line 15. on line 15, where is the that cell tower located?
So again, it's on 285. It's just a little bit more further northeast. Again, describing it towards the Roswell Road exit without zooming in on the map. That's my description.
Okay. Now looking, and what time was that?
0718 UTC, so that's 3:18 a.m. Eastern Standard Time.
Okay. And looking at number 16,
All right.
what time is it?
So that's 0728. So a 10-minute jump forward. The next communication we have at 0728, which is 3:28 Eastern Standard Time.
Where is the cell tower located?
Cell tower is going to be located near I-75. As we can see, the 75 marker there. It's 75, again, in between 285 and the connectors. I believe what I said yesterday. But it's that, I think it's Paces Ferry. I said north side, but that's wrong. I think driving in, I saw it was West Paces Ferry. That's kind of like a general description. I don't know how accurate that is, but in that area, as we can see on the pin drop.
Okay. Now looking at 736, or excuse me, the next one should be 737. Oh, I'm sorry, 736. I apologize. You can bring it down. I'm sorry. What time is that?
0736 UTC, which is 3:36 Eastern Standard Time.
Okay. And where is the cell tower located now?
As we see, that's the Grady curve right there, as we call it. Grady being right there, the Capitol being here. So it's just on 75 to 85 south of that location. And for just another description purpose, that straight up and down, north and south, is the Metropolitan Parkway area right there.
Okay. And looking at number 18, the next line. What time is this?
So that's going to be 7:37, which is just 1 minute later, and it's 3:37 Eastern Standard Time. Very much still the same kind of area, just to cell tower a little bit more north than the last one we saw.
And then looking at 738.
So very, very similar location, 738, it's 3:38 Eastern Standard Time. And again, cell tower is just a little bit south of where it was just last time. It wasn't just there, now it's moved a little bit more south again. Tower being communicated with.
And then last 753. What time is that?
So 753 is going to be 3:53 Eastern Standard Time. Yes.
Okay. And where is that location?
So it moved kind of away from the 7585, and now we have it south of 20 and kind of east, that would be west of 7585, and then kind of more towards the, I guess, the Metropolitan Parkway 20, I-20 kind of intersection there.
And again, is that where the vault was located?
It's vault's located on Metropolitan Parkway. Correct.
And are these last few, are the cell towers roughly in the same general area?
Same general area, roughly in that south of I-20, 7585 area.
And now looking back at we'll call this the phone number for Jimmy, the Jimmy Winfrey phone number.
Okay.
Kimberly, no, this guy is the lead detective was the lead detective in the case in the bus shooting. But he also has training in cell tower interpretation, something. So for the past, half of yesterday and more today, he will talk about cell tower. Oh, Gwendolyn, that was a different cell tower case. This is a new cell tower case. And just to make sure, this prosecution have an actual cell tower expert lined up who will take the stand. I don't know if he does it directly after this guy, but they will have another cell tower expert.
At about that same roughly 3:58 time, where is that cell tower?
So similarly, which we discussed, I guess it was 2 days ago, possibly now, Metropolitan Parkway. So without having plotting it right now, it's generally going to be in the same kind of area down there, Metropolitan Parkway.
And based upon your plotting, was that phone in that same area between 3:58 and 4:27?
Correct.
Now,
Please make it stop.
when it came to the plots that you did, did you plot every call in the 1990 record?
No, what I did was basically every hour from almost like, what was it, 10 p.m. Eastern Standard Time, every hour leading up to the 3 a.m. Eastern Standard Time. And then that's when I kind of started picking some right around that crucial time, just to give us a general overview of the movement of the cell tower being communicated with.
What about the 3383 record? Did you plot every call on that record?
No, I didn't when I was doing my basically spot checking early on in the investigation.
And why didn't you plot every single call on a record?
I mean, it's time consuming, but that's the purpose of sending it to the analysts so they can use the software to plot every single record utilizing the software.
With the phone number 1990, for the calls that you plotted, were all the phone numbers that were being contacted significant to your investigation?
Not all. I tried to identify as many as I could through investigative methods, but I can't say that every single one was 100% involved and important to the investigation.
And so then why did you plot those calls?
Because we got the location data off those calls from when the phone communicated with that tower.
Now, when you receive these records, are you ever able to get the contents of the phone calls as to what was said on the calls?
No, that's not the type of search warrant that we got, and that it's historical in nature. So when we get this type of search warrant, we get what's called CDR, call detail records. So we know who called who texted who, as in the phone numbers. And then if we request in the search warrant the historical cell site data, which is that location data from the cell phone company of the towers, we'll get that information. But we have no way of hearing content of past historical phone calls.
Now, in looking at what you plotted for the 3383 number, which we'll call the Jimmy Winfrey number, and the 1990 number, the YSL Enterprise number, as it relates to the compound area, can you tell from the records which number got to hit a cell tower first in the compound area?
I would say that Jimmy Winfrey phone number got to the compound area prior to the 1990 YSL Enterprise phone number.
Sir, you have an objection?
I do.
Basis.
Beyond his qualifications and has to be a use of the talent for the rest of my judgment. I would add speculation.
Go ahead.
I can rephrase it.
I'll sustain the objection.
Based on the cell tower that you plotted, which phone hit a cell tower closer to the compound first? The 3383 Jimmy Winfrey phone or the 1990 YSL Enterprise phone?
3383 Jimmy Winfrey hit the cell tower closest to the compound first.
If you can recall, was there ever a time, if we need to go back to the chart, that the Jimmy Winfrey phone hit a tower at the compound around the same time that the 1990 number was hitting a tower near the compound?
Mr. Jingles joined us. Hello,
Yes,
Mr.
they did.
Jingles.
I can recall, and yes, they did.
Okay. And when did the 3383 phone hit a tower going towards 285?
Yes.
Did the 3383 number hit a phone going towards hit a tower going towards 285 around the same time that in 1990, the 1990 number hit a tower going towards 285?
Yes, we saw that in the records.
And do you recall the jail call that we heard in which Jimmy Winfrey asked someone to call the 1990 number?
Yes.
And is that the same 1990 number as we've just been discussing this morning?
Yes, it is.
And is that the same call where female answered the 1990 number first
Correct.
and then passed the phone to Mr. Williams?
That's also correct.
Now, in your investigation, or during the course of your investigation, excuse me, did you do any online searches for any information that was assisting your investigation?
Absolutely.
Why did you look on the internet for information regarding your investigation?
First off, I was trying to learn of basically the dispute, the conflict, whatever was going on, as described by Atlanta police. So I was trying to do my own research. I was also just trying to gain information and knowledge about the involvement of the parties that were involved, and also because we find evidence.
Sir, objection?
Object to the
Basis.
parties who are involved.
Overruled, sir.
Go ahead.
Yeah, so continue on. Basically, at times, suspects, criminal defendants, offenders, whatever you want to title them, post information that could be useful as evidence on social media as well.
And were you able to find anything on the internet that assist you with your investigation?
Yes.
The items that you found on the internet, what were the sources of that information?
I looked at Instagram, Facebook. I looked at YouTube. I looked at just general Google searches, just Googling names. I was just generally querying anything and everything that I could to get information back.
And when you saw information that you thought were relevant for your investigation, what did you do with those? What did you do with that information?
I tried to preserve it to the best of my ability.
And how did you try to preserve it?
Whether it was a screenshot, whether it was downloading a YouTube video, whether it was actually sending a preservation request in to the service provider, whether it be at the time Facebook, Instagram, now it's Meta, but just sending a preservation request in and then getting legal process later if I needed to do so. So I was just trying to collect it by any means at my disposal.
Now, with some of the videos that you pulled, did they sometimes come from bloggers?
Yes. Mm-hmm.
And can you describe for the jury generally when they came from bloggers, what were the bloggers doing? Yeah, I'm not asking what did they say.
I'm over the objection, Mr. Steele.
Of course you do.
Without saying what any of the bloggers said, what were they doing? What were they doing?
Overruled, sir.
So most of the blogger type content or news type content I was getting from YouTube, and most of them were just highlighting and discussing what's going on, the ongoing conflicts.
I sustain the objection. Ladies and gentlemen, jury to instruct you to disregard the witness's last statement.
Oh,
Let me ask you this. in the blogging videos, would they splice videos together?
Yes, there were splices. Yes.
So they altered the content of the
And then
videos.
would they, now tell me what it says, would they provide their own commentary over the spliced videos?
Yes.
I wonder if my commentary will be used in the trial. I hope against Fannie Willis,
Why did you
Miss
get
Love,
that
and
type
Judge
of
Glanville.
video? Why would you pull that video from
Overrule, sir.
Well, it's basically like a force multiplier. Other people are going out and scouring the internet for information. They're compiling it, and then I could go to one source and get that information. So instead of having to go to this webpage or this social media post or this page, someone else is kind of doing the work for me. I just download it from one source.
What's the basis of your objection? Well, you cannot speak your objection. Just tell me what the basis of the objection.
It's total speculation, right here say.
I'll overrule your objection.
Personal knowledge.
Overrule, sir. You may answer, sir.
Basically, it's a force multiplier. Compilations of videos and posts are being pulled in one location. I could go to one location and download as much information as I could get from one source.
That's not a source. That's some guy
And
making commentary like I do.
Have you been able to review at least 2 of the videos that you pulled based from your investigation?
Yes.
And it was
First,
so
I'm gonna show you
shitty.
what's
All of
been-
this, they had to coerce a plea deal out of Murphy. It was so bad evidence that they didn't charge anybody else for this bus shooting. It was so incredibly lousy police work. They had to coerce Murphy into a plea deal. And here he is. The world's most boring cop. Should be ashamed of yourself.
Already admitted, it's State's Exhibit 118 Echo.
Want to show the same fucking pictures again?
Sure.
I think it should be just.
Why are you muting? This is, oh, Jesus Christ. What the fuck? And you know, I've been copyright struck a few times during my coverage of this trial. And so I can't show music or stuff like this. I have to, yeah.
What time does the 1990 number contact the 5790 number?
Yes.
Okay, at what time?
We see it at 0707 UTC, which is 037 a.m. Eastern Standard Time.
And looking at the actual record, do you know if that phone actually connects and at what time? In whichever.
It'll be the 19. Oh, okay.
Right now, he's gonna be looking at the demonstrative, which is gonna be Stacy's Exhibit 172. Stacy's Exhibit 139 Echo.
So yes, so at 0307 1990 attempts to call the 5790 phone, and it's the phones at least connect for 3 seconds.
Jesus. There were a lot of attempts of calls, and at one point it was 3 seconds. There's someone calling, someone answering, can't hear shit,
And is
hangs up.
that looking at 139 Echo Charlie depicted on 139 Echo Charlie?
Yes, it is.
Now, on 139 Echo Charlie, based on the actual record, are there 2 actual entries at 307?
That's correct. There's 2 lines that indicate as such on the records.
And, Ms. Knight, can you put the map back up for this line?
Mr. Jenkins, I hope you feel cuddly today, because seriously, this is... I mean, the entirety of the bus incident was litigated a long time ago. It was such a shitty investigation that they had to coerce Mr. Murphy into a plea deal. Neither Stilwell or Mr. Williams was ever charged with anything here. And they have... I read a blogger, and from that I got evidence. This is so stupid. This is so incredibly stupid.
And at the time in which these calls are made, is this a tower that's traveling on Atlanta Road?
Yes, correct.
And is that the same direction that the bus was traveling up Atlanta Road?
That's correct.
And let me ask you this, did you ever plot the YSL Duke phone number?
No.
Why not?
The YSL Duke phone number, I only got a subpoena for. Therefore, I did not get location information because it was a subpoena versus a search warrant where I could get location information from.
Any reason why you only got a subpoena for that record?
Oral, sir.
At the point in time when I was getting the search warrants, the importance of it wasn't, I didn't understand the importance of it at that point in time.
Now, looking at all the records, the 1990 number, do you ever see that phone number call the YSL Enterprise phone number that was assigned to the last digit 8553?
Yes, in the records, we do see that, yes.
Do you see those 2 numbers calling anytime around April 26th, 25th, and 26th?
So the 1990 and that phone number you just mentioned, the 8553,
Yes.
we're talking about the time period in which we were discussing now, the incident.
Yes.
No, we don't see those connect, no.
So why the fuck are we talking about them? If they weren't connecting throughout this. Jesus fucking Christ.
But we do see that number calling the YSL.
I stand objection.
Do we see the 1990 contacting the YSL Duke during this time period?
Yes,
And Duke, was he the individual on stage with Mr. Williams in Baton Rouge, Louisiana?
I stand objection.
So somebody called someone who's happened to be on the stage at the same time as
You can take
Mr.
that down for me.
Oh, for fuck's sake.
I'm now going to show you what's been admitted as 6 Exhibit 117, Echo.
Gigi, you don't have to, but thank you so much for a $2 super chat.
Yeah, YSL.
Again, I can't play this because I will get copyright struck.
Now, is that one of the videos that you pulled?
Yes, I pulled that video.
This has already been shown multiple times to this jury. This is compound. It's been shown a number. Jesus Christ, Judge! You told the prosecution to not waste time. You told them all to not waste time. How is this not wasting time?
You know,
Now, from where did you pull that video from?
I mean, from YouTube, from the internet.
Was that one of those blogger videos that we talked about earlier?
That's correct.
And when you pulled the video, did that video already have the videos kind of spliced together as you discussed earlier?
It was already spliced together by them. Correct. Yes.
So somebody
And let me ask you,
altered the
is there a portion of that
content.
video missing
Yes.
from what we see? What portion of that video is not being shown?
Commentary.
And who was that commentary from?
The blogger, the person that posted the video.
So this lead detective is now testifying under oath that this was not from Mr. Young Thug. He took something from Young Thug and spliced it in with something else. We don't know if they are actually connected, just that somebody, I mean, there's a lot of grifters out there that will find this 5-year-old video with some fun stuff and this 12-year-old thing and smash it together and see if it gets the numbers.
When you pulled it, did you do any editing to the video?
No.
It was already edited. For fuck's sake.
Did you add anything or did you remove anything from what you pulled from the YouTube site?
I'm not that tech savvy. I just downloaded it.
That's the objection.
Please let it go.
Did you ever obtain any social media records?
Yes.
Specifically, did you obtain any records from Instagram or Facebook?
Yes.
Who did you receive Instagram records for?
Multiple parties, but I did it for Jimmy Winfrey, who was the suspect in this case. I did it for some other involved parties as well.
What were the other?
Hold on.
Would the statement involve parties?
Oh, sir.
Let me ask you a better question. I'll ask you more specifically. Did you pull records for Mr. Jeffrey Williams?
I did.
What about Shannon Stillwell?
I did.
Were they cleared? Did they bring
Were
charges?
there
No.
others outside of these three?
There-
I stand the objection.
The
Sitting
state,
here now, do you recall
the state will definitely not call the actual vlogger, because that vlogger might sit on the stand and say, that piece of garbage cop? No, I put that and that together for chasing clout. It has nothing to do with the whatevers, and they will not risk that.
handles for each of the Instagram records? Miss Jimmy Winfrey, Jeffrey Williams, and Shannon Stillwell.
Oof, I could probably name a couple of them, yeah.
Okay. Do you recall it for Jimmy Winfrey?
He was Pee Wee, aka Roscoe, I believe, on at least one of them.
What about Jeffrey Williams?
You would ask me that. I'd have to refresh my memory by my report.
Okay.
Yeah, I have to refresh my memory.
And what about Shannon Stillwell? Do you recall?
I think his was OG Bull. I think I remember something like that for him.
This is Mr. Winfrey. This is your.
I'd have to refresh my memory by my report.
I need to listen
Okay.
to that
Yeah, I
again.
have to refresh my
And
memory.
what about Shannon Stillwell? Do you recall?
I think his was OG Bull. I think I remember something like that for him.
Yeah, Sylvia. This guy on the stand has no clue. Did the prosecution forget to prep him? We should get fairly close to lunchtime. So a heads up is that at lunchtime, I will break for the day and will return tomorrow morning at around 9:30, 10 a.m. with a recap of today's afternoon, and then we will catch up on live. Yeah, Sylvia. They used him to authenticate a phone call, and then he testifies that he has no clue. This is so stupid. Folks, this is the core of the prosecution's case. Absolute incompetence. Absolute incompetence. But the judge allows it. Still reviewing what she tries to get in. Maybe these guys actually have a written report that hasn't been destroyed. Remember the gang experts that testified last week and the week before that retired? And then mysteriously they could only retrieve the evidence that speaks towards the prosecution. All the other things mysteriously gone. And that is the core thing in this prosecution. They know it's garbage, but Fannie Willis wanted to become the Attorney General, and they don't get there by day-to-day crimes. She wanted to get there by RICO trials. Thank you for being here, Gigi. Everybody say bye to Gigi, my first and best moderator. Oh, come on.
Okay.
Get on with it.
Was marked as 163 Echo, 163 Echo Alpha, 163 Echo Bravo, 163 Echo Charlie, and 163 Echo Delta, and 163 Echo Echo, and 163 Echo Foxtrot. So first take a look at those, tell me if you recognize those items.
I do recognize him.
And how do you recognize, first start with 163 Echo.
So 163 Echo Alpha, which is the disc. I viewed the disc and put my initials on it. I guess it's 2 days ago, on the 13th.
And what was contained in 163 Echo?
He didn't see and initialized it until 2 days ago? This is his evidence from 2015. And he didn't proffer it until 2 days ago? What the fuck?
The Instagram response to the search warrant.
And then because of the record, what was contained 163 Echo Alpha.
That's the response from Instagram reference the search warrant served on them for Jimmy Winfrey.
And what is the vanity name? Vanity name?
So the vanity name listed is that Pee Wee, aka Roscoe.
What is 163 Echo?
163 Echo is the business record certification, is what we call it for the records.
Now it's 163 Echo Beta.
Bravo.
Excuse me, Bravo through Echo.
Echo Foxtrot. Oh.
Is 163 Echo Bravo Echo X. Sorry. Is 163 Echo Bravo through 163 Echo.
Yeah.
Echo.
Prosecutor is testifying.
Correct, yes.
Container 163 Echo.
Correct.
All right. And it's 163 Echo.
Shields asks, what's my opinion on the judge saying he believes the conspiracy is proven? Well, it's only proven in the what's the word? Preponderance of the evidence. And that is the hurdle, the first hurdle to get it into this trial. And that is a call he makes. I think it's a horrible one, but that's just my opinion. Sadly, this judge, spineless Judge Glanville, lets everything in. Almost everything in.
Oh, Foxtrot, the subscriber information.
Yes, that's the page that contains that, yes.
You're right, this time the state would like to tender 163 Echo, 163 Echo Alpha.
Does looking at all these evidence help you testify about it? Yeah, probably. Did you collect it yourself, or are you just testifying to collecting it yourself? I'm not sure, because the incompetence of almost every cop on the stand during this trial is staggering.
163 Echo Charlie, 163 Echo Delta, 163 Echo, and 163 Echo Foxtrot is evidence.
Any further objections on behalf of any counsels that have otherwise not been previously noted?
To the extent that the written materials are admitted, I don't have any objection. Any extraneous things that may be on the disk.
We talked about that yesterday, and I've noted your objection to that or your concern. Okay, anybody else?
This is Mr. Winfrey, true.
Yes, that's the one.
Your Honor, I will object if he's not here to hearsay.
Overruled, sir. Overruled. States 163 Echo Alpha, Echo Bravo, Echo Charlie, Echo
Of
Delta.
course he allows it in.
Echo and Echo
Of course.
Foxtrot are admitted, over objection.
Yeah, Mr. J.
or
Scheme.
related caveats.
The judge calls himself a
maybe publishers
gatekeeper.
should
Here's the
see
thing.
before we do
He
that, though.
keeps his gate closed as
you
much
take comfort
as
Okay, all right. Ladies and gentlemen, let's take 10 minutes.
Mia
okay?
Khalifa
All
used to
All
do
right.
with her legs. Oh, are we going to... Okay, jury's out. Is it a hearing or is it lunch? Or is it going to yell at the defense again? Yeah. It's going to yell at the defense again. You absolute Judge Glanville.
All right, ladies and gentlemen, our
spineless
jury is
piece
left
of
us, so we'll be in
shit.
recess
You
10 minutes. Okay?
fuck twat. Oh, I'm sorry, the YouTubes. I'm trying to say quad. It's my accent. It comes out weird when I say it. Oh, it's lunch. Did you say lunch?
10 minutes. Okay.
10 minutes. Oh, why? Why? It's seriously, Judge. It is noon. It's almost noon. And you want to have a 10-minute break? Jesus Christ. Yeah, again, Judge Glanville lets everything in. And here's what's going to happen. Judge Glanville, his 10-minute breaks are at least 20 to 25 minutes. So what's going to happen is they come back and he calls for lunch. That is what's going to happen because it is past noon in Atlanta, Georgia. And I can't. Yeah. So this is what's going to happen. We will watch the rest of today tomorrow. I will start the stream around 9:30, 10 a.m. tomorrow morning. And Jesus Christ. I'm trying to make this as entertaining as I can with you guys. But you all know that this is a complete cluster F of a trial. And now we are into a part that is so incredibly boring. So I think I will do it more justice by doing more of recaps on this. Am I still oh, I haven't been green for no, I'm not. This stream has no monetization whatsoever. Nothing. And haven't for quite some time. I'm about to sneeze, sorry. Oh, Jesus Christ. Just trying to... Dun, dun, dun. Dun, dun, dun. You know what? I see that Andrew Branca is doing a stream. So I will be sending you off to him. Let's see if I can find it over here. Yeah. Yeah, yes, Ghostery. Recap gives me time to recover between days. And that way I can throw out all the irrelevant and stupid things and give to the meat of the bone. So, oh, thank you, Devance. Thank you. Yeah. Because sitting here and listening to the world's most boring cop, I can't justify it. I really can't. Hopefully he soon will be done and I can skip through to the cross-examination because cross-examinations is generally interesting. Okay. Yeah, I'm going to send you over to Andrew Branca. But before that, thank you all for being here. Thank you for allowing me to try to translate what's going on for you. I hope I can have Dave on other occasions or other lawyers to help me translate this to you. But thank you again. Thank you for the super chats. Thank you for the Rumble rants. Those occasional, that is what keeps this channel afloat. And finally, as I always say, hug your family. Unless your family is shit, then screw them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.